joining us today. My name is Karen Stumpfel, and I'm the Marketing Director for Morris Law Group. I'm here with my colleague, Attorney Joshua Glaser, who is in a separate office due to our firm's social distancing guidelines. Today, Josh is going to discuss our entity compliance program and process, particularly as it relates to our generational planning solutions and GPS perpetual plan compliance. He's going to share a screen with you, and he has a presentation ready to go, so I'm going to pass it over to him. Take it away, Josh.
Good morning, everybody. Thank you for joining us today. As Karen briefly mentioned, my name is Josh Glaser. I've been an associate attorney with Morris Law Group for a little over 4 years now. And today's discussion topic is our entity compliance program within our overall GPS program. For those of you that are obviously on this program, you're familiar with our GPS. However, I want to delve into the specific component of our entity compliance piece today. So, our first topic on the agenda is the actual different types of entities that we work with and that most of you, especially our members of the program, have for themselves. So, first and foremost is the most common. We have our LLCs, our limited liability companies. In a general definition, this is a state law entity with very flexible and elective income tax treatment and provides extremely strong creditor protection in Florida and many other states. However, the one caveat is that it needs to be a multi-member LLC in order to get this significant protection. The next type of the entity that we work with that we see amongst our clients are corporations. So in general, a corporation is an entity that's separate and distinct from its owners. The shareholders take profits through dividends and appreciation of all the stock. And from a creditor protection standpoint, shareholders are not personally liable for the corporation's debts. However, creditors can reach the individual's shares of the corporation. The final category of entity that we work with a lot is the concept of the partnership. So there are essentially two types of partnerships that we work with. Number one, I want to talk about the limited partnership, or the LP, in which is defined as an entity with two or more partners. You have your general partner who runs the business. This general partner has unlimited liability for the debts of the partnership. However, we do like to have this in order to shield liability by having an LLC act as a general partner. And we have our limited partners who have no active management and therefore they only have limited liability to the extent of their initial investment. The next type of partnership is the LLLP, the limited liability limited partnership, again, which has two or more partners. Here we have the general partner who runs the business. However, unlike the LP, in this case, the general partner does have limited liability. And once again, we have our limited partners who do not partake in any of the management and have limited liability. One important item to note here is that we do a lot of LLLPs in Florida and Delaware, but not every state has a statute permitting the LLLP. However, the two primary states we work with for LLLPs are Florida and Delaware. Now that we discussed the types of categories of entities that we work with within our entity compliance program, we want to get into more of why we actually find this important and why we go through this entire entity compliance process. As you can see from the top of this page, the key component here is the asset protection or the creditor protection that these entities actually offer. So in order for the proper asset protection to be provided within these entities, you have to make sure that the entities are actually maintained and are kept active properly. So here I'm going to delve a little bit further into the actual creditor protection offered within these entities. So the first category, again, we have our LLCs and LLCs, which stands for multi-member LLCs. These types of assets are protected from personal creditors in Florida and many other states. The sole remedy available for a creditor to come after a person's interest in a multi-member LLC is to obtain a charging order, essentially meaning that the creditor will only get paid if the LLC distributes assets to that member. So essentially, if those assets are left within the LLC forever, that creditor is not getting any money out. Next, we have our corporations. And just in general, the shareholders are not liable for any of the corporation's debts. And as we discussed, we have our LPs and LLLPs. Within our LPs, we have our limited partners not liable for any debts, whereas the general partner can still shield their liability through having the general partner set up through an LLC. Lastly, we have our LLLPs, where, again, very similar to the LP structure, full liability is, there's limited liability for both the general partner as well as the limited partner. Now, delving further into why we do what we do and what this program is all about. So, in order for an LLC, a corporation, or a partnership to achieve its max potential with regards to asset protection, there are two key things that need to be done. Number one, the entity needs to be active, and number two, the entity needs to be maintained annually. So the reason for this is, in order to access assets of these types of entities, creditors will, first and foremost, they're going to make an argument that, okay, this LLC, this partnership, this corporation, it's not a real entity, it's just a sham, and you've only created it to hide your money from us. So although that argument, is definitely going to be made anyway, we want to make sure that we want to plan for when this argument is made, and we want to make sure the entity is completely legitimate, it's active, and fully maintained as a fully operational entity. And again, this argument that the creditors are going to make, it especially holds true for entities, for LLCs and other types of entities that are used solely for passive and investment assets. Essentially, they're going to make the further argument, well, you're only holding these assets in these entities to hide the money from us. Well, so moving on, now that we know why we're actually going ahead with this program and what needs to be done, we're going to get into the more specifics. So before we get involved with the actual maintaining of the entities, number one, we want to make sure that all the entities, in order to make the argument that they are fully legitimate, they have the proper organizational documents. This is the operating agreement. Obviously, that applies to the LLCs. They have bylaws, which applies to the corporations, and we have the agreements of LP, et cetera, or LLLP, which applies to the partnerships. We also want to be sure that we have our corporate books with the necessary certificates in there, and we have all the other organizational and annual meeting minutes, which is another function of this program, which we'll get into in a little bit. So moving on, in order to, again, for these entities, in addition to having the proper organizational documents in place for asset protection, we want to make sure that the entities are actually being treated as proper entities within themselves. So first and foremost, we have our contributions and distributions within the entity. So for instance, in order for the entity to really be functional for asset protection purposes, all the contributions and distributions need to be done pro rata or pursuant to any other original agreement. If the members or the shareholders are not compliant with pro rata distributions or distributions according to the agreement, again, this only helps the creditor's argument that this entity is a sham, it's their personal piggy bank that they're using for asset protection purposes for no reason. And lastly, again, in order for the asset protection, most importantly, for the asset protection to be applied, the entity must be maintained on an annual basis. And obviously, that is the brunt of our entity compliance project. So there are actually two major components to Morris Law Group's annual maintenance and entity compliance program. Number one is the annual report, and number two is the annual meeting minutes. So the annual report, as many of you are familiar, any entity that you have, especially the ones in Florida, there's a due date of May 1st. This is, for lack of a better term, this is the state of Florida's shakedown fee for keeping the entity active within Florida. And obviously with all the current circumstances with the virus and everything delayed and shut down publicly, the state of Florida has delayed the filing for this year through June 30th as opposed to May 1st. Extremely, extremely important. The most important factor here is that the failure to file the annual report on any given year essentially results in the dissolution of the entity. So the problem there is now that the entity will no longer exist for state law purposes, and therefore for asset protection purposes, that entity is no longer there. And therefore, because that entity is no longer there in place, because you didn't pay that fee, the assets within it are technically exposed to creditors. The second major component of our entity compliance program, in addition to us making sure that the annual report is filed, we will also prepare the annual meeting minutes. This should be done annually, and therefore we will do it annually. It needs to be signed by each owner, whether it's the member or shareholder or partner. And essentially, it documents all the actions and resolutions of the preceding year. And once the meeting notes are prepared, we actually add it to the corporate book. So again, this lends a significant amount of credibility to the fact that the entity in place, whether it's an LLC, partnership, or corporation, is a legitimate operating entity, and all the necessary maintenance is done on a given year, happening all the time. So we've talked a lot about the types of entities, the types of asset protection offered by having the entities, the importance of maintaining the entities. So now we can get into a little bit more specific of what our entity compliance program actually does and why it's so important that that these entities are maintained, whether it's through us or without our help. So here's essentially what our entity compliance program will do. Number one is we will make sure that the entity's annual report is filed with the state. Again, this makes sure that this is not just Florida, this is for any state that you have the entity in. This makes sure that that entity still maintains its status within that proper state. Therefore, for asset protection purposes, it stays in place. We will prepare the annual report and make all the necessary, we will coordinate all, in addition to coordinating the annual report, we'll make sure all the proper payments are made. We will review the entity's managers, directors, registered agents, and the addresses, again, to make sure that's fully up to date. It would look foolish for asset protection purposes if an entity has been sitting there for 20 years and doesn't have the most recent information of the members or shareholders or partners. We'll make sure for entities outside of Florida, we will make sure that the registered agent fees get paid. This is most notably in Delaware. For those of you who work with CSC, we'll make sure that they get paid on time so they don't drop you as their client. We will review each asset owned by the actual entity on a continuous basis. We'll prepare as we mentioned earlier, we'll prepare the necessary meeting minutes each on an annual basis. We will advise on the proper, and we'll advise and facilitate to make sure that all the contributions or distributions have been done properly, obviously on the pro rata basis or pursuant to the agreement. We will review the tax returns and the K-1s to make sure the ownership is accurate, and we'll make sure that to ask you for the actual K-1s and tax returns to update any ownership as needed moving forward for the annual minutes. And again, we'll prepare the actual meeting minutes each year. And most importantly, you see in capitals on the bottom, is that we ensure that these entities maintain asset protections for the owners. I know that was a lot of information in a fairly short period of time. I hope you enjoyed this, whether it was on a lunch break or a coffee break. But please, if you have any questions about our program, please do not hesitate to reach out to myself, Karen, Stuart, Mike, or any of the other individuals you've worked with significantly with in our office. And please let us know. And thank you for your time. And we look forward to seeing you for our next presentation.
Thank you, Josh, for that great information. We hope you enjoyed today's presentation. If you have any questions or would like to schedule a consultation with one of our attorneys, please give us a call today at 561-750-3850, or you can email info@law-morris.com. We're doing all of our consultations right now over the phone or over video conferencing, and all of our signings are being held in our safe outdoor plaza. Once again, thank you so much. Stay well, and we'll see you at the next video.